8, 9, and 10 will adopt the submissions that we have already given in this matter to save time for the other petitions. We want by the request now that once the other petitions are done, we will then allow the document only 10 minutes to prosecute the contempt application, as we had said, so that it's all considered together. That's our request.
So the other petition that adopted is 181.
Yes.
Have adopted the substitution. So we go to 111. Italiano. 217 of 2023. 217 is culture office.
Leadership in the mountain mining story, getting together with my learning colleague, leadership and leadership in petition 217. It raised 5 fundamental questions that this honorable bench should consider under the Finance Act 2013, 2023 invalid. Your Lordship, our Lordship, I'll proceed to one of the questions that has been posed for deliberations and consideration. Is whether section 52 and 63 of the Finance Act threatens the consumer economic rights of small business enshrined under Article 461C of the Constitution. My lords and my lady, Section 52 and 53 introduces electronic tax system and makes it mandatory for all the businesses to issue receipt electronically. At the same time, to keep their tax records electronically. Your Lordship, we humbly submit that this violates the rights of small businesses, for the reason being that it's expensive, it's not convenient for the small businesses, for the reason being that they will be required to obtain electronic devices, be it computers or laptops, for the daily transactions with their businesses. And they will also, the law requires, mandates these small businesses to keep the records in electronic form for a period of 5 years. My lords and my ladies, these small businesses are prejudice on the basis that they are not making enough profit to enable them to run their businesses. Therefore, acquiring these electronic devices make it expensive. And therefore, there is Article 461C that guarantee the economic rights of our Kenyan people. The second question that has been posed to the deliberations is whether Section 38 of the Finance Act threatens food security under Article 43 1C of the Constitution. Your Lordship and Lordship, Section 38 of the Finance Act amend value added tax, that is number 35 of 2013, and exclude the stable food in this country from the list of zero rating items that being in this one, cassava flour, and wheat. Your Lordship and Lordship, history provides right that maize is a staple food in this country. That by deletions and exclusion of the same item in the zero rating will prejudice our citizens of this country because they will not be in a position to access and enjoy the stable food in this country. So the amendments introduced by Section 38 violates the food security entitled under Article 43(1)(c) of the Constitution. Another question has been posed to this honorable bench to consider under the Finance Act 2023 and Constitutional Section 38 of the Finance Act. The same Finance Act section within the Act introduces other items around 8 to be zero rate, but at the same time excluding the stable food. This poses two threats. One is it allows some of the items and equally enjoyment of the law, at the same time excluding the stable food which this country, the people of this country should be entitled to enjoy. And by the exclusion and inclusion of other items, violate tax principles provided under Article 201, that equality enjoyment of the law has to be improved as provided under Article 27 of our Constitution. The fourth question that has been posed to this honorable court is the issue of housing levy. The reason why we object to the introduction of housing levy under Section 84 of the Finance Act is that the amendment doesn't present the views of the people of Kenya. These are only views of the elected leaders who enjoy delegated powers, indirect powers that they exercise. The final, the housing levy is not practical in the sense that if we do adopt an estimate figure of a purchase of a unit of a house, let's put 1 million per unit that has to be purchased. If we calculate 1 or 2% of the deduction of the salary, that means that in the course of the year, the collected amount is 24,000. If you multiply that amount, if you do calculation, it might take almost 100 years for the Kenyans to benefit from the housing levy. Therefore, the introduction of the housing levy is not practical in these circumstances. The reason why we still raise constitutional issue in regard to the housing levy is Article 40 of our Constitution. That protects the right of property rights. Your Lordship, if by the scheme under the mandate the government elected at the end of the day is to ensure that this housing levy is collected, and the government to identify specific place where these properties can be raised, constructed, and be delivered to Kenyans. We submit that violates the rights of Kenyans, specifically at Article 40, for the reason being that there are some Kenyans who've already acquired the houses. They enjoy a place where they should live, as provided under the Constitution. And therefore, if the government is mandated to choose to identify and construct houses in specific places, that is not a pure enjoyment of their property rights. On the last issue, on the issue of public participation, sovereignty, and the values, Your Lordship and Lordship, I do submit that we first responded to that National Assembly as provided under Article 1 of the Constitution. Article 1, sub-article 2, that people may exercise their sovereign power either directly or through their democratic elected representative. We do submit that the Parliament that encompasses the National Assembly and the Senate, they are mandated to legislate laws that represent the views of the people. And the best where Kenyans can exercise the indirect supervision of the powers for the elected leaders is through public participation. Your Lordship and Lordship, we do submit that yes, there was public hearing. As you retire, you look at our submissions. The essence of the public participation is not only to call the citizen to participate in the process, but their views must count at the end of the process. In this Finance Act, we do submit that was not considered, Your Lordship. It's not a matter of beauty contest, it's a matter that the citizen of this country must submit to them. Your Lordship and Lordship, as I finalize, we request this Honorable Bench, pursuant to Article 23, Article 165, 258, 259 of the Constitution, to declare the Finance Act constitutional and allow the petition as read.
Thank you. E219 of 2023 calls out.
My Lord, my name is Nyakirita. I am in 211 Chief. I know that I can't be allowed to.
You wait till we have jumped that one. Wait for your chance. I call it. To E219 of 2023 calls out.
My Lord, if I may,
Yes.
my name is Emeto.
Yes.
Honorable Tiende Amolo.
Pardon?
Honorable Tiende Amolo has already addressed petitions.
E21 2023 National Notice of Kenya.
Which is the court. Matter, my name is Uri. I will address the report for about 5 minutes and then let another 5 minutes. Section 84 of the Finance Act. I adopt the submissions that have been made with regards to the housing fund. That has set out in Article 201 of the Constitution. We submit that amendment fails to meet the constitutional threshold. The fact that Section 84 amends the Employment Act, and the preamble to the Employment Act related purposes. To that effect, we submit that we enjoin the submissions that have been made. The lack of a framework to anchor violators in fact effect and brings to full uncertainty within the law. To benefit from the scheme in the absence of a framework law. And that goes to also the impropriety of the public notice appointing the Kenya Revenue Authority as the body to administer the housing related. There is also the question of whether the act can be enacted in such a way in light of the provisions of the Constitution, and particularly that gives to the county the function of housing in Schedule 4 and the function of creation of policy. Our Lord, it is our submission that to adopt any other interpretation would be to give the development of policy a different meaning. And to that extent, we also join in the submissions that were made by Mr. Chele Molo, that section would in effect be seeking to amend the Constitution. But for those reasons, we join the rest of the petitioners in imploring at this point to find that section 84 of the Finance Act violates the Constitution for the reasons that we have stated and the reasons that we have stated in our submissions, and to proceed to declare that section constitutional, void, and with no effect on the law, to consequently order that any funds that have been collected would be refunded. Lord, I seek the floor to write to Mr. Good morning, my Lord. As my president has indicated, my name is Koloma. I'll be submitting briefly on the issue of whether meaningful public participation was conducted in as far as the third reading introductions, the provisions that were snuck in at the third reading. My Lord, for clarity, these are sections 24C, paragraph 72 and 73, section 44, 47, 5, 100 and 11 of the Indian Act. Yes. Section 24C, paragraph 72 and 73. Section 44, 47, subsection 5, section 100 and section 101 of the Impute Finance Act. My Lords, my Lady, there have been extensive submissions with respect to this issue of public participation. Mine is only to address the rejoinder that has been
put forward by the respondents. My lords and my lady, the respondents hide behind the standing orders 133 to allege that it allows them to introduce amendments at any stage of the legislative process. My lords, my lady, they further state that the introductions were in fact products of public participation. And on the basis of these two arguments, they claim the same to be constitutional. My lady, that proposition is both factually and legally unfounded and mistaken. First, my lady, on the basis of fact, it is the respondent's submission that there was proposals by Sanabil, Kenya Wines Agencies Limited, and Tatu City Limited, as well as KPMG, that resulted in the introductions of these new provisions. In fact, from the report of the committee, it is only Kenya Wines Agencies Limited, whose proposal was received and amendments to that effect accepted. My lords, my lady, even just this argument in itself reveals a problematic issue of partiality. My lords, some proposals by the stakeholders were rejected by the Finance Committee for want of public participation, for the very reason that they were being introduced at that stage. My lord, I refer you to page 86 of the report of the Departmental Committee on the Finance and National Planning, where they rejected KPMG's proposal on the basis of the stage at which it was being introduced. Yet, the other provisions that were introduced at the very same stage, they seem to now hide behind and say that they came from the public. My lord, secondly, to demonstrate that they are legally unfounded, that position is legally unfounded, to propose that the Standing Order 133 overrides constitutional and statutory dictates is a shock to the petitioners. My lords, my lady, in fact, the drafters of the very same standing orders were of the same view that these standing orders must be read in line with the Constitution and statutory provisions. Hence why Standing Order 133.6 clearly provides as what are allowable amendments at the committee stage. My lord, it clearly provides and I will refer this court to the authority Kenya Bankers Association versus the AG and another. Where the court was very clear that no amendment shall be moved which is inconsistent with any part of the bill already agreed to or any decision already made by the committee. My lord, in fact, the standing orders further say that the additions must be minor amendments and not substantial additions. This is a position that the apex court of this land, my lord, in the BBI case, the AG and two others versus Ndi and 79 others. I'll refer this court to paragraph 270, 302, and 1938 of the Supreme Court's decision. And most notably for this court's understanding, the court simply indicated that there is no evidence of any form of public participation or deliberations between 21st October 2020 and 25th November, when changes to the BBI steering committee draft bill, including the second schedule, was added that show public engagement and consideration of the issue of apportioning and allocating the subject counties, additional constituencies. My lords, my lady, we humbly submit that it is an issue that has been clearly and unequivocally determined by courts, both at the Supreme Court level and at the Court of Appeal level. What is the ambit of the amendments that can be introduced at the committee stage? It cannot be that substantive additions are made in the guise of minor amendments. And to allow such an infraction would be going against the principle of public participation, where Parliament can introduce completely alien provisions in the guise of introduction from public participation. My lord, last year we only addressed the issue of the retrospective application of the law for the period that it had been suspended, and only to respond to the rejoinder given by the respondents. And my lord, very notably, they all hide behind the fact that, according to the impugned section 31C that was introduced, the collection period of this housing levy is 9 days after the preceding month. So for them, the argument is that the collection period was after July. So the 9 days, the first 9 days of August. My lord, we are not here to argue on the collection period of the levy. We are here to submit on the date of the effective date and when the housing levy came into force. My lord, for that period, there was a conservatory order that had suspended the implementation from 1st of July up until the date that the court lifted the conservatory order. For that reason, it is our submission that any implementation of that provision of the law, of the impugned act, during a period when there was a subsisting conservatory order suspending its implementation, amounts to retrospective application. My lords, my lady, that will be all.
E227 of 2023, Azimio la Umoja,
There is one last.
no, let's take your chances. E227 of 2023, Azimio la Umoja, Kenya Opposition.
But my lords and my lady, with the kind permission, my name is Ochieng Odinga. I do appear together with my colleague, Ms. Wangui Njoroge, who is present. On behalf of the petitioners, I will be relying on the amended petition dated 31st August 2023, together with the affidavit sworn in support of the same by Raila Amolo Odinga, written submissions dated 31st August 2023, and a list and bundle of authorities equally dated 31st August 2023. I wish to center my submissions on two broad areas, namely taxation and devolution, in light of the Finance Act 2023. Now, the first issue I wish to address is whether sections 2 and 84 of the Finance Act are unconstitutional. And to that extent, I submit that the two provisions are unconstitutional and in contravention of Articles 10, 110, 209, 186(2), and 210 of the Constitution. My lord, pursuant to Article 110 of the Constitution, a bill concerning county government means a bill containing provisions affecting the functions and powers of county governments. Now, for that proposition, my lords and my lady, I refer the court to be guided by the decision in the matter of the Interim Independent Electoral Commission, that is Constitutional Application number 2 of 2011. that is contained at page 12 of my bundle, and more specifically paragraph 40, where the Supreme Court pointed out and stated, we consider that the expression any matters touching on county government should be so interpreted as to incorporate any national level process bearing a significant impact on the conduct of county government. My lords. Now, in this case, my lords and my lady, section 2 and 84 contain provisions touching on entertainment tax and the housing levy. My lord, I submit pursuant to paragraphs 8, part 2 of the 4th schedule, county planning and development, including housing, is a key function of county government. And the role of the national government is only limited to initiating a housing policy. It cannot go beyond that. But now for that proposition, I invite the court once again to consider the decision in the Law Society of Kenya versus Cabinet Secretary, Ministry for Lands. That is at paragraph 11 of my submissions. Now, more specifically at page 35 of my bundle, at paragraph 54 in that decision. Now, the court emphasized and stated the words housing policy and housing are used in the 4th schedule in respect of national and county government functions. Now, the mandate of the national government involves the accreditation, regulation, and promotion of quality assurance and technical capacity assistance in the construction industry at large, while the county government is involved in housing to the extent of planning and development within the counties. So that, my lord, housing matters are an exclusive preserve of the county government. My lord, in further interpreting paragraph 8, part 2 of the 4th schedule, I invite the court to apply the principle in Tinifunza versus Republic, whereby the constitution is to be interpreted as an integrated whole, with each provision complementing and supplementing each other. Now, my lords and my lady, you'll be told that housing function is a socio-economic right in Article 43 of the Constitution, and hence it is a preserve of the national government. Now, I submit, my lord, whereas housing is one of the socio-economic rights under Article 43 of the Constitution, the Constitution is expressed when it lays emphasis on these socio-economic rights that are to be co-shared between the two levels of government. My lord, in fact, if you look at Article 204.2, for example, it specifically introduces the equalization fund, and it states, my lords and my lady, permit me to read, the national government shall use the equalization fund only to provide basic services, including water, roads, health facilities, and electricity to marginalized areas, to the extent necessary to bring the quality of those services in those areas to the level generally enjoyed by the rest of the nation so far as possible. So that in this provision, my lord, the services referred to are also contained in Article 43 of the Constitution. But in this case, the Constitution has gone further to specifically delimit these particular functions to denote that they can be co-shared between the national government and the county government. My lord and my lady, secondly, Section 2 of the Finance Act introduces income tax on income generated from digital platforms. My lords and my lady, I submit that Article 209 restricts the nature of taxes to be imposed by the national government and restricts it in form of imposing entertainment tax, so that the digital platforms income encroaches on the entertainment tax under Article 209 of the Constitution, so that again the Act itself encroaches on the mandate of the county government. And again, under Section 2, the digital content monetization, as defined under the Act, is ambiguous and uncertain, my lord, and the same is contrary to Articles 160, 186.2, as read with Article 293 of the Constitution. Now, I refer the court to the decision one the court to uphold the holding that, in my view, this is the court speaking, the respondents cannot be allowed to usurp the mandate and powers reserved to another state organ under the guise of collection of revenue for the country. My lords and my ladies, again, you will be told that the speakers made a decision and determined that the bill does not involve the counties. I submit that the determination of whether a bill concerns county government is not an exclusive preserve of the speakers of the two houses. This court has the ultimate powers pursuant to Article 165 of the Constitution to determine and make a pronouncement on that question. So that in this case, that decision is being treated as if it is a private affair between the two speakers. But we submit that is a decision, an administrative decision, that is subject to review by this honorable court. And hence, this court reserves the exclusive jurisdiction to determine the validity of a decision by the speakers made under Article 110, subclause 3 of the Constitution. But now on taxation, on the second limb of my submission, first I begin by saying that it is tried law that legislation needs to contain certainty and clarity. So that this principle, my lords and my lady, has been described as a fundamental tool in the legislative process. Now, permit me, my lords, to refer the court to the article by one author, Alexander Deming. It is titled Certainty and Uncertainty in Tax Law. That is a Siberian Federal University Journal publication. Now, my lord, I refer specifically to page 133 of my bundle, where the author identifies 4 key elements underpinning clarity in taxation law. Permit me, my lords, to read. First, the author points out that certainty in law is the cornerstone of the state governed by the rule of law. The lack of certainty in law deprives it of its ability to perform its functions effectively, to form a stable legal order, and to direct, in bracket, guide people's behavior in particular. And then, finally, the principle of certainty of taxation is the ideological basis of all modern taxing systems. Now, secondly, my lord, permit me to refer also to the 7th article on my list of authorities, that is Daniel Dick. The article is titled Neutrality and Legal Certainty in Tax Law and the Effective Protection of Taxpayers' Rights. This is and Acta Juridicum Hungarica Budapest Journal publication. So that for that article, I refer the code to page 163 of my bundle, where the author points and says, taxpayer rights can be exercised effectively in a well-established system of tax law. It is important to look for the quality of tax legislation. In other words, to know about the conditions in which the tax law can be considered as ideal. It should apparently rest on a sound normative basis. My lord, the other authorities are also wish to rely on and articles, but the upshot of the submission, my lord, is that tax legislation has to be certain, so that in applying these principles, my lord, if you look at, for example, the housing levy, first, what is apparent from the responses tendered so far is the definitional challenge. We don't know, the taxpayer does not know whether it is a levy or a tax. What is it? That is the first definitional challenge, which ought not to be the case for any taxing legislation. Secondly, the imposition and enactment of that provision ought to have involved both houses of parliament. Again, the housing levy is uncertain on the mechanisms that will be used to achieve affordable housing. It fails, for example, to disclose how the funds will be computed, raised, disbursed, and utilized. My lord. Again, on the final issue, on the legality and constitutionality of the Act, I quickly point out to Section 33 of the Act, which introduces VAT on compensation. So that in that context, my lord, Section 33 is contrary to Article 24 of the Constitution, as it introduces a limitation on the right to property under Article 40. And it does not pass the threshold for limitation of rights. Finally, as I conclude, my lords and my lady, I urge the court to allow the petition, and I invite the court to reiterate the findings by the Supreme Court in the matter of the Speaker of the Senate, that is authority number 10 in my bundle of authorities, where the Supreme Court was emphatic and stated as follows: it emerges that Kenya's legislative bodies bear an obligation to discharge their mandate in accordance with the terms of the Constitution, and they cannot plead any internal rule or indeed any statutory scheme as a reprieve from the obligation. Then secondly, the Constitution vests the legislative authority of the Republic in Parliament. Such authority is derived from the people. And finally, my lord, pursuant to Article 93(2) provides that the National Assembly and the Senate shall perform their respective functions in accordance with the Constitution. So that as I close my submissions, my lords and my lady, any legislative process that falls short of the constitutional muster can be best described as legislative deception. That's all.
Thank you very much. E228 of 2023, this is Kenya Human Rights Commission, Achievement Situation of the Social Accountability, Transparency International, and International Commission of Jurists. Others, so it's likely.
Thank you, my lord. My lord will make 5 highlights. My lord, I make 5 highlights, relying for the rest of the argument on my written submissions. I'll highlight the issue of regressive taxes, the statutory instruments question. I'll take you through the public participation issue, my lord. And lastly, the climate change violations. And then I'll conclude with the issue of money bills and money bills concerning counties. Well, beginning with the issue of regressive taxes, Article 10, 21.3, 201 demand that taxation must be fair. In the Charles Macharia case delivered last week by the Supreme Court, the court restated the Article 21.3 obligation of all state organs to redress the needs of the vulnerable. In that case, children in juvenile justice, in this case, the poor in taxation. Now, the World Bank, in its June 2023 economic update for Kenya, indicates that Kenya has been beset by an economic polycrisis because of the worst drought in 40 years, because of the lingering effects of COVID-19, and because of the ongoing global economic meltdown. The National Treasury acknowledges that. If you look at page 94 of the 2023 BPS, National Treasury tells us that for the first time in 5 years, the rate of inflation is above the government target. First time in 5 years. And what is the impact of that? It pushes millions into severe food insecurity. And that set of circumstances has a legal effect. It invokes Article 10, social justice, protection of the marginalized. It engages Article 21.3, measures to protect the vulnerable. It invokes Article 201, equitable and fair tax measures. Lord Adam Smith and Atia Waris, whom we've cited in our Landlord Authorities, explained that fairness, the word used in Article 201, demands that one must pay in proportion to their income. And so, my Lord, Mr. Sore will tell you that this is theoretical, but there's something called a regressive tax. A regressive tax is not fair because it pushes the burden to some people more than others. It affects the poor disproportionately. One of in 2018, the National Treasury confirmed that doubling VAT on petrol violates the rights of others because it increases hardship, it reduces disposable income. And the other thing that BPS tells you, my Lord, is that the poor spend more than 60% of their income on food. Ordinary households spend about 54%. It is in the BPS. And so, when in an economic crisis, where government is saying that there's a runaway inflation, life has become hard, then you double VAT on the cost of petroleum. You impose excess duty on fish. You target milk specially formulated for infants. You double, you impose excess duty on product use, food stuff. Then that is a regressive tax. My Lord, it's reminiscent of 1 Kings 12:12, where the people tell King Rehoboam that we're suffering, can you lift our burden a little? But he says, double. That is what happened. I turn next, my Lord, to the argument that the National Assembly makes. It says that these are policy issues. Do not go into them so that you do not interrogate the fairness of the taxes imposed by the Finance Act 2023. This same argument was made in William Museni. Policy is mentioned 23 times in that judgment, that case which I argued. same issue, dressed as political question doctrine, is made in the CDF case, again, which I had. The Supreme Court had the CDF case. My Lord, the Finance Act, even if you cannot determine issues of policy, the Finance Act is an act. It is not a policy. What you cannot do is decide which policy option the state should make. But once the state makes a policy decision, then it's justiciable. Under Article 10, anyone who formulates a policy or implements a policy, or under Article 165, if anything done or said to be done under the Constitution. So, my Lord, that should get rid of that argument. I turn to the climate change issue, my Lord. Now, they increase excise duty on glass bottles and on paper packaging. What is the impact? The impact on increasing excise duty on paper packaging, imported paper packaging, is to pile pressure on our forests, is to make people to resort to unclean options like plastics that violates or threatens Article 42. And it is irrational, my Lord, considering the Climate Change Act 2016, and that this year, Kenya has hosted one international conference on climate change and will, in November, host another on reducing plastic pollution. Yet, this is the year that the National Assembly chooses to impose excess duty on glass bottles, on paper packaging, and to increase VAT on natural gas, a clean energy option. Please find that those climate-leading amendments violate the right to clean and healthy environment. Lord, permit me to turn briefly to the money bill question. Now, if you look at Article 109.5, 109 the entirety, a bill can be introduced in any house. But under 109.5, a money bill may be, the word is introduced only in the National Assembly. National Assembly, the Attorney General carry, take the word introduced and magically transform it to debate. They say that a money bill can only be debated in the National Assembly. Lord, that would violate Article 96 because and the Constitution cannot subvert itself. So you must harmonize. Harmonize 96, harmonize 109.5, and harmonize another article. That is Article 114. Article 114.2 explains why the Constitution demands that a money bill may only be introduced in the National Assembly. And that is because under Article 114.2, National Assembly is given an initial filtering role. One of the few, if not only, situations where the Constitution directly imposes a duty on any committee of Parliament. You will not find it anywhere. Under Article 114.2, the National Assembly must only proceed only in accordance with the recommendation of the relevant committee of the Assembly after considering the views of the Cabinet Secretary responsible for finance. That is why 109.5 says you can only introduce a money bill in the National Assembly in accordance with 114. 114.2 says when a money bill comes in, you can only proceed after considering the views of the committee one and the committee itself after taking into account the views of the CS Treasury. My Lord, that reading is constitutionally compliant. It honors the obligation of the Senate to protect counties. It honors the role of the National Assembly to play that initial filtering role, and it respects the value of bicameralism. My Lord, what can affect counties more than their revenue? My Lord, this is an argument accepted by the Supreme Court. In the CDF case, the Supreme Court was told that look at the objects of this amendment bill. It has nothing to do with counties. It does not mention counties. but the Supreme Court found that the CDF Amendment Act, not the entire act, the Amendment Act, was a matter concerning county governments because it impacted county revenue. My Lord, under Article 1 and 2, revenue raised nationally is shared equally among national and county governments. So the more the Finance Act raises, the more counties have to share with the national government. The less it raises, the less they have. The Finance Act is a matter concerning county government. And my Lord, it's not just about that revenue. The other things they put in housing, statutory instruments, including those made by counties. And my Lord, I turn next to the statutory instruments issue, repeal, the Statutory Instruments Act, whose Section 21 is repealed by Section 88 of the Finance Act. First, it is not a money bill issue. It shouldn't have been in the Finance Act. My Lord, if you look at the list of the statutory instruments, page 56 of our amended petition, you'll find there the Witchcraft Act, Cap 67. What does the Witchcraft Act have to do with finances? Mr. Sole will tell you that because of 114, these are incidental matters, they can go into money. The Witchcraft Act, my Lord, how is it incidental?
Probably the chiefs will have less work.
The subordinate courts separation and maintenance. Well, not I bet my colleagues to just allow me 3 minutes to finalize. The subordinate courts separation and maintenance act, Cap 153. What does that have to do with taxes, with levies? It is not a money bill issue. The Telegraphic Press Messages Act, Cap 512, which you find at page 62 of our amended petition. One of the last time I heard of a telegraphic message. In short, they put money bill issues into the money bill, the finance, and this is why they did that. In May this year, and Annexure CN 1, 2, and 3, you'll find a resolution cancelled this by the Senate, refusing to extend the life of some 1,700 statutory instruments, whose term had expired under Section 21 of the Statutory Instruments Act. My Lord, that state automatic expiry as a constitutional value. If you look at Article 96(4) of the Constitution, delegated legislative power is limited. It's limited because Parliament itself is exercising a delegated power. And so when it gives it to the Cabinet Secretary, it must retain some control. And so the power to make delegated legislation is controlled. Section 4 of that Act, the Statutory Instruments Act, requires mechanisms, my Lord, to ensure the ongoing review of statutory instruments to ensure their continued relevance. Regulations made under the Witchcraft Act still bind the Kenyan people. You'll find regulations made under repeal acts. The law is that if you repeal a statute, the regulations continue unless separately repealed. And so, my Lord, the purpose of Section 21 was to ensure the ongoing usefulness of statutory instruments. The National Assembly knows this. Look at CN 5, which is the report of the National Assembly, at page 552. It's the National Assembly, I quote, notes the importance of constantly reviewing the statute. The Senate also knows that. You'll find that at CN Roman numeral 1 at page 51 of our amended petition. The Senate says it's important to scrutinize the statutory instruments to ensure their relevance, justification, and rationale to extend their life. And my Lord, they can only extend for 1 year, 12 months. And so the purpose and effect of
of repealing section 21, my lord, was to defeat that Senate resolution. And you hear the Senate speaker telling you that they had agreed with the National Assembly speaker that this bill did not concern the Senate, despite this agreement. And so, my lord, find that one unconstitutional. Look at the Queensland Statutory Instruments Act 1992. It explains also the rationale for state expiry in a manner that concurs with what the National Assembly and the Senate say. My lord, allow me to conclude with the issue of meaningful public participation. My lord, we decided the CNC case. Justice Odunga decides over Nakuru. There are other decisions. And my lord, we are not saying that every view presented must be adopted. No, that is not the claim here. We are saying that every view presented must be considered. That is the law. My lord, that is the law in BAT Supreme Court. That is the law in the GIFT principles, the global initiative for financial transparency, which Kenya has signed up to. It's also the law in the OECD principles, clarity of subject matter, my lord, complementarity. The view presented must be shown, must be considered, and the state organ must demonstrate how they took into account that view or why they rejected it. My lord, look at page 398 and 399 of CN5. You'll find this remark. The committee rejected the proposal by LSK. Full stop. Rejected. Was there a better view? Was LSK disliked? Rejected. My lord, page 467, Okoa Uchumi, the people I represent. The committee rejected the proposal. Full stop. Rejected. What is the reason for rejecting? Trade Union Congress is a petitioner here. Page 469. The committee rejected the proposal. Full stop. My lord, the report does not show that every submission given was considered. My lord, there's worse. The KRA at paragraph 44 tells you, 44, that the National Assembly considered all views given, but 44 times, CNX 5, the CFA and TROS counted and found 44 submissions left blank, without a reasoning, without indication of what happened to that, 44 times. And my lord, about 80 submissions cannot be accounted for. What happened to them is not known. And so, my lord, we submit that there was no meaningful opportunity for balanced influence of the decision. The last one, Okoa Uchumi, page 316 to 361, makes 57 submissions, nearly 60. Only 4 are records. Of those 4, 2 are marked as the committee rejected the submissions. My lord, there was no meaningful influence, meaningful opportunity for public influence. And I apologize to the police.
Mr. Oganda?
Oganda.
Oganda.
Those together for the 6th and 7th petitioners. Your Lordship, Your Ladyship, I pick up from where Senior Counsel Otiende Amolo left, and he equated this court to the bastion and bulwark of constitutionalism in this country. Quickly, in terms of comparative constitutional law, the year is 1919, August 11th specifically, whereby the Weimar Republic ushers a new constitution after the fall of Germany. That constitution is important for this reason. It had a Bill of Rights, and it properly recognized the individual as the locus of authority, just like our Constitution 2010. That constitution had a shelf life of 3 years. It failed. Why did that constitution fail? For these reasons. When it was deliberately undermined by legislation under it. Two, it was deliberately undermined by political action. Your leadership, your lordship, you are the bulwark, the bastion of constitutionalism. And we have submitted to you our authority number 1, page 1 to 72 of our bundle of authorities, that legality, the principle of legality, is one of the tools that the judiciary uses to examine the acts of state. Your lordship, Justice Mugambi, you asked a question on public participation. It has been flogged enough, but I want to give precise bullet point answers. Public participation is a principle enacted to address limitations of representative government. Therefore, if I had time, I will take us to the history of democracy in its incipient stage, whereby we used to sit as Africans around tables and make decisions through consensus. There's a tool called the Boule, B-O-U-L-E. The Greeks had the Agora, whereby decisions were made from a small platform. That is what public participation intends to do, to take us to that environment where decisions were given meaning and at least accounted for. Secondly, Your Lordship, legislators do not always represent the views of the people. In theory, they are supposed to. In fact, they do not. Our fast past the post-electoral system has ensured that certain ethnic minorities are excluded by the majoritarian interests, and therefore they are dominated, excluded from governance. That is why public participation and the need by public participation. There is the BAT case that issued guidelines. I had a position here that Parliament is considering legislation on public participation. I take a different view. Once the Supreme Court has synthesized and distilled the elements of public participation, given as constitutional law, qua Article 94 of the Constitution, that is law. Parliament has no business legislating on it. So the guiding light for this law, in terms of what amounts to public participation, we go to the BAT case by the Supreme Court. And the Supreme Court, echoing what George Vincent Odunga said in Ex parte Gakuru, those two decisions give a conjunctive test. There's a qualitative and quantitative element to public participation. Those elements have not been met. I simply move next to the impugned notice by Cabinet Secretary in charge of housing, ostensibly in exercise of powers under Section 84, read together with Section 31 of the Employment Act. Error. Under the law, Section 2 of the Employment Act, as read with Section 91 of the Employment Act, the authority to make rules and any instrument worth calling itself a statutory instrument under the Employment Act is within the domain of the Cabinet Secretary in charge of labor matters. Not the CS, housing and transport. I can almost best my dime that I will be told there's the principle of collective responsibility, and therefore any CS can do what was done in those impugned notices. Those of us who studied law at second year remember the principle of delegatus non delegate potest. A delegate cannot delegate any further. So when you are a CS and statute delegates to you authority to make rules, that has to be read with interconnectedness with Article 94. And therefore, when Parliament, through the Employment Act, specifically identifies the officer that is the Cabinet Secretary for Employment, that Cabinet Secretary cannot delegate it any further. My brother Ochiel has submitted, and others have submitted, on the Statutory Instruments Act. That act has to be read together with the provisions of the Interpretation and General Provisions Act. The following provisions complement the provisions of the Statutory Instruments Act, the Lordship and Leadership, Section 27 of that Act. All subsidiary legislation have to be published in the Gazette and shall come into operation on the day of publication. Important. The question is, this notice appointing KRA as an agent, in addition to the shortfalls identified in the Statutory Instruments Act, impugns Section 27. Retrospective application, Section 28 of that Act answers us. I will invite the court to look at it. Section 33 of this Act, acts done under subsidiary legislation are deemed to be done under the Act which authorizes. Again, addressing our argument, Section 2, Section 91 of the Employment Act, the Cabinet Secretary who ought to have issued guidance, who ought to have appointed KRA, if at all, was the Cabinet Secretary in charge of employment matters, not labor. Employment and labor matters, not housing. Section 34 requires that any instrument in the nature of rules and regulations has to be laid before the National Assembly. The notice, the impugned notice and the agency notice to KRA holds out in its Austinian sense, John Austin. We were forced to obey the command and we remit taxes or levy, whatever it's called, ostensibly because of those rules. Your Lordship, those rules ought to have been submitted to the National Assembly by virtue of Section 34 of this Act. In conclusion, and as I wind up, a lot has been said about policy, that this court ought to keep off political questions. The lead decision of Justice Joel Ngugi in the BBI case, David B. and others, ably captures the authority of this court as captured in Article 165, such that merely a threat to the Constitution is an invitation for this court to deal with that threat whenever it occurs. The Constitution 2010 baptizes this court as a Kelsenian court. This is a court that is supposed to do judicial review. And judicial review under the context of the Constitution 2010 and reading specifically the principal provisions, Article 10, the Constitution 2010 mandates this court to even examine policy considerations, however crafted. Anything that lacks legitimacy cannot be effective. Lacking in effectiveness, they cannot develop legitimacy. Those are not my words, those are the words of Samuel Huntington, a wave of democratization in the late 20th century, attacks in political science. Basically, anything that was not procedurally, constitutionally infirm cannot be a material of governance. Anything done without according to the authority of the people and the sovereign locus under the Constitution 2010 cannot be baptized, cannot be solemnized by an imprimatur of this court. We humbly submit. Thank you.
Thank you very much. E 232 of 2023, Robert Katogo Kamara.
My lady and my lords, my name is Robert Kamara. For the record, I will be relying on amended petition dated the 9th of August 2023. My affidavit sworn on the 9th of August 2023. My father affidavit sworn on the 24th of August 2023. My written submissions dated 24th, and my supplementary written submissions dated the 8th of September in response to the first and second respondents' submission. My Lord, yes, my Lord, on the way here I carried 4 stones, but I was denied to come with them. So I'll simply explain them and I wish you visualize them. And my 4 stones, my Lord, one of them is openness, thickness, accountability, and ambiguity. I want to put section 84 on the weighing scale. And my Lord, the purpose of doing this is to demonstrate how section 84 is ambiguous. In this case, I'll be asking a question. Is section 84 of the Finance Act unconstitutional? And the answer is the affirmative. This section has been enacted to ensure that there is as much opaqueness as there can be. Why do I say this? When the Finance Act, when the Finance Bill was brought to the public for the public participation, the Finance Act, the Finance Bill in itself stipulated clearly the issues that through the Employment Act would be amended and the benefits that the members of public, those who are employees and employers, would benefit from. I'll read in brief the small titles, the marginal titles. One of the things that was supposed to be amended was that there would be a national housing fund, a national housing development fund. My Lord, my lady, in the enactment of the Finance Act, nothing like this was demonstrated. Further to that, the Finance Bill was clear and it had stated that employees are to qualify for affordable housing. And who are these? It clearly stated, and it is said that employees would benefit and they would be financed for purchase of a house. The Finance Act that came out, my Lord, my lady, did not have that. The Finance Bill further was clear on how funds would be transferred back in the event that somebody retired and did not need to use the monies that he paid from his employment. The Finance Act does not address that. It's clear that the space between the Finance Bill up to the time of the enactment of the law, there was a lot of ambiguity that took place. No openness came out, and we can comfortably say that the act is purely ambiguous. It is meant to confuse. Initially, it was very clear, but later it was meant to confuse Kenyans. Article 10 and Article 201 on principles of public finance, the Public Finance Act clearly states that everything should be open and there should be no thickness in anything. There was no transparency. Bearing in mind that the Constitution has only provided for 4 kinds of taxes, that is the income tax, VAT, excise, and customs. We are blind to where this housing, affordable housing levy should be allocated. Fine. The legislators are saying, the respondents are clearly saying that there is Article 292 that allows the creation of additional taxes. The legislators can put in new taxes. But in this case, where can we present the housing levy to? It is not clear. The first respondent, in his replying affidavit in paragraph 24 and 25, alleged that the funds were to be governed by the National Housing Corporation. However, the Act is silent. The Act does not say where the money is going to be, fund is going to be taken to. These are a lot of funds. The month of August itself, a lot of monies were deducted from all these people who are seated here. and those also in the bench. The monies were deducted from their salaries, but truly the money cannot be accounted. I wish to now bring to your attention my second point about opaqueness once again. And section 84 states that the levy shall be deducted from the gross pay of employees. What is gross pay? What is gross pay? The fourth respondent has attempted through an instrument which I'll call a public declaration or a roadside declaration that gross pay is 1, 2, 3, 4 things. There is nowhere in the Income Tax Act that this has been properly defined. There is nowhere gross pay has been defined. In that case, the public finance management legislation states that there should be clarity, and the purpose is to collect as much as possible. We can tell the reason why the Finance Act put in the affordable housing is purely just to collect money, monies that cannot be accounted for. Therefore, we can say no accountability, despite the fact that we want to collect as much using the ambiguous methods of collecting cash. I'll rely on my panel of documents on paragraph 24, Republic versus Domestic Commissioner of Domestic Taxes. And my lord, on this, I'll rely on the Delico Oil Refineries versus Attorney General. In the judgment, it was clear that it is within the authority of the legislature to enact legislation governing the manner in which a particular form of taxes is to be administered, including the manner in which it is to be imposed. Therefore, the legislature did not cover or did not undertake its work to fully ensure that Article 210, to ensure that the taxes that were being created were not properly collected. Article 201 and Article 10 then can clearly be seen to be infringed, because in Article 10, accountability, national values, good governance on how the funds are going to be utilized does not seem to be coming out. Further, this demonstrates that in section 84, there was a lot of ambiguity because the fifth respondent purported to appoint the fourth respondent. However, it should be the vice versa, where we have the CS, Treasury, who should be appointing Kenya Revenue Authority and not the CS of lands appointing Kenya Revenue Authority to do the collection of tax. Under what law was the appointment done? It is clear that there is ambiguity and that there was no clarity on those issues, and therefore the reason why they had to quickly try and circumvent and
two parts where we talk about both purpose and the effect of any legislation, because sometimes the effect can be good, but the purpose is lost. What then was the purpose of the Finance Act? By its name, it's an act that helps the government raise finances to cater for its budgetary expenses for financial year 2023-2024. The petitioner, in the petition before you, is aggrieved by the effect of the said act on the constitution, which I now proceed to address you as follows. One, all of us in this group might know that it's been stated that this Finance Act was the most popular act in the history of Kenya. Without evidence, I don't want to go there, but all we know that it was least intellectually debated. As my colleague said, reject, reject, reject. There was no intellectual discourse. So on the public participation, on the face of the petition that is before you, we have shown and demonstrated that the certain sections of the Finance Act were amended when the act was still a bill before the floor of the House of the third respondent, that's the National Assembly. Honorable members of the court, public participation is a constitutional requirement under Article 10, Section 2 of the Constitution. Consequently, I invite you to find that the extent that the in-punch clauses, which you have stated, were introduced to the bill and are not subjected back to public participation, in their express view, the said sections are violative of the constitutional principle of public participation, which serves the purpose of informing the public of what is expected and to their concerns and fears. The second one, on discriminatory nature of the housing levy, in contravention of Article 27 and 43 of the Constitution of Kenya 2010. My lords and ladies, the housing levy as passed under the Finance Act requires mandatory contributions from both the employer and employee. It means therefore the right to housing provided for under Article 43, Section 1 of the Constitution of Kenya 2010. The effect of this is that only the persons who are employed will have the benefit of being able to have the right under from the issues affecting Kenyans, like the Court of Appeal bill and the Supreme Court of Appeal. Just do the right thing. Don't be scared of the injustice already done by the higher courts. Because we believe that from the low courts, you can get justice, and sometimes justice appears as you go the sky above. And I would like to plead to you that you might be able to consider the rights of Kenyans who are suffering in these taxes as being listed here in many ways, and the inconsistencies in it that you make before you. With those few remarks, I urge you to allow the prayer sought in the petition number E237 of 2023 as prayed. I thank you, my lady and lords, for listening.
Thank you. Mr. Jerry Lugo.
Yes, he was in the same petition.
Since it is not here, we move on to the next. E254 of 2023, Mr. Arwa. Mr. Arwa, you need to name to the time of the parties.
My lord, my lady, in that matter, as I indicated earlier, I am here together with my colleague Mr. Dunga of all the petitioners. Unlike all the other petitions, this particular petition challenges only one provision of Tenasa, specifically section 47, paragraph 8, subparagraph Roman 12.
Section
47A, Roman 12. My lords and my lady, the position of the petitioners is that this particular provision is unconstitutional and should be declared much. The main reason why the petitioners contend that it is unconstitutional is because it was never contained in the bill that was published on 28th of April 2023 and which was submitted to public participation. My lords and my lady, there are several other issues that we intend to raise, most of which have already been touched on. Therefore, I will not dwell on them. I'll only touch on the aspects of our submissions that have not been submitted on by my department. And specifically, my lords and my lady, I will be addressing basically the 6 issues. Number 1, how do constitutional values implicate the legislative process? Number 2, what amounts to a bill for purposes of Article 109 of the Constitution? Number 3, what does public participation in the legislative process entail? Number 4, what does amendment of a bill actually entail? 5, what is the implication of the impugned section on the right to health? And finally, what is the implication of that particular legislative provision on socioeconomic rights entrenched in Article 43 of the Constitution? So I will start with the first issue. The implications of constitutional values on legislative process. My lords and my ladies, I submit that this is not an idle point. I will start with Article 10, Sub-Article 1, Paragraph B. And this is what it says. National values and principles of governance in this article bind all state organs, state officers, public officers, in all persons, whenever any of them, in paragraph B, enacts or interprets the Constitution, any law or the Constitution. And also, my lady, the substance of my submission is these constitutional values bind Parliament. In every step they take in the legislative process, must take into account these values. Specifically in relation to section 47 that we are complaining about, it is admitted by all respondents that it never read paragraph 10 of the affidavit sworn by Samuel Njoroge on behalf of Parliament. He clarified, my lord and my lady, that when the bill was at the committee stage, some proposal was presented to the committee. And it is this proposal that was eventually passed into law. Essentially admitting, my lord and my lady, that this proposal was introduced on the floor at the committee at the third reading stage. That, my lord and my lady, will see in paragraph 10 of the affidavit sworn by the Speaker of the National Assembly.
The question therefore is whether a bill and a proposal which is introduced at that late stage can be enacted into law without being taken back to public participation. Now, the submission, my lords and my lady, is that it is not possible. And it's important to note, my lords and my ladies, that Parliament was very much aware of it. My lords and my ladies, to look at years 80, 81, and 86 of the report that was presented by Parliament next to the affidavit introduction. In those 3 pages, you will see that Parliament actually rejected other proposals that were introduced for the first time at that stage. Meaning that they were, and the reason given was these matters have not been taken for public participation. So what we see here the Lord and my ladies, is a situation where Parliament selects which new proposals to enact into law and which new proposals to reject for failure to comply with public participation. And it is our humble submissions, my Lord and my lady, my Lord and my lady, that Parliament cannot do that under our constitutional dispensation. Specifically, Article 10 entrenches the value of integrity, the value of transparency, the value of equality, and the value of good governance. All these values bind Parliament. The value of integrity cannot permit Parliament to choose which new legislative proposals to accept and which new legislative proposals to reject. They must act with integrity. And this is a constitutional imperative. Secondly, my lords and my ladies, the value of transparency requires Parliament to explain to Kenyans on what basis they reject some new proposals and on what basis they accept other new proposals. It is a duty which they have to explain to Kenyans. New proposals are being accepted and others are being rejected. Otherwise, we are going to encourage impunity and arbitrariness in our constitutional dispensation. That is, my lords and my ladies, Parliament owes a duty to all Kenyans who submit proposals for their consideration. And where two Kenyans submit new proposals at that late stage, it is not fair for Parliament to choose to treat one of them differently from the other.